They left his house open to the sky for 14 days. Not open the way you leave a window cracked on a mild evening. Open the way a house becomes open when half its roof decking has been stripped to bare wood. When the emergency tarp stapled across the gap on day 2 pulls loose on day 5 in a wind that comes off Lake Michigan without asking permission. And when the man who took $11,000 to fix the problem stops answering his phone on a Wednesday morning and stays stopped for 2 weeks, while the weather makes its own decisions about the interior of a house built in 1958 by hands that are now 81 years old and still steady, but no longer able to climb a ladder to the second course of rafters. The contractor's name was Joel Burkett. He operated a company called Premier Home Solutions from a leased office in a strip mall in Muskegon County, Michigan. And he had a website with a rotating banner of completed projects that my aunt later determined were stock photographs purchased from a commercial image library. Joel had taken my grandfather's $11,000 deposit on a Tuesday, started work on the following Monday with a crew of 3 men who appeared to know what they were doing, and by Wednesday of that week had reasons to pull the crew that had nothing to do with the roofing project and everything to do with whatever Joel Burkett did with money when he got his hands on it. My grandfather, Bernard Acaffer, is 81 years old. He came to the United States from Nigeria in 1971 with an engineering degree, $40, and the specific kind of ambition that does not announce itself because it is too busy working. He spent 38 years as a civil engineer for the Muskegon County Road Department. He retired in 2009 with a pension, a complete understanding of load-bearing structures, drainage coefficients, and soil compaction ratios, and the practical knowledge that comes from spending 4 decades watching what happens to construction projects when the people running them cut corners on materials. He built the shed in his backyard himself in 1984. He has maintained every system in his house through 8 presidents and 2 significant recessions. When Joel Burkett's equipment trailer sat in his driveway for 9 days full of roofing materials purchased with money my grandfather had earned across 4 decades of county road work, my grandfather made a calculation that combined his engineering knowledge, his practical equipment experience, and a patience that 81 years of living had refined into something close to perfect. He did not bury the trailer immediately. He documented first. My name is Adiz Acaffer. I am 36 years old. I am a licensed attorney in Michigan specializing in elder financial exploitation and consumer protection. My grandfather called me on day 6 of Joel Burkett's absence. By the time I arrived at his house the following morning, he had 11 days of documentation, a folder that would have been impressive from a professional investigator, and a specific plan involving a compact excavator he had reserved from a rental company 2 days earlier pending my legal assessment of whether the plan was defensible. "Granddad," I said, looking at the reserved excavator confirmation on his kitchen table, "walk me through the legal theory." He poured coffee and sat down across from me and said, "Possessory interest in converted assets." I looked at him. "Where did you learn that phrase?" He said he had been reading. Comment below where you are watching from. Because this story ends with a contractor's license revoked, a scheme that had victimized 19 homeowners across 2 Michigan counties, and an 81-year-old civil engineer who knew more about soil compaction and asset recovery than Joel Burkett had adequately researched before he took the deposit. Bernard Acaffer built his house in 1958 the way he built everything, which was correctly and with sufficient margin for the unexpected. 3-bedroom colonial on a corner lot in Norton Shores, Michigan, 600 feet from Lake Michigan's eastern shore, which means it has been subject for 66 years to weather that comes off the lake with the particular indifference of large bodies of water to residential architecture. The house had been re-roofed once before, in 1991, with 30-year architectural shingles that had now served 32 years, and were showing the compressive failure and granular loss that 30-year shingles show when they have given what they were designed to give. The leak had started 2 winters earlier. Small at first, the kind of drip that a strategically placed bucket manages through a season while you decide how to address the larger problem. By the previous spring, it was no longer manageable with a bucket. The north slope over the primary bedroom was soft in 2 sections. The flashing around the chimney had failed. Water was finding its way to the ceiling joists. Bernard had gotten 4 estimates over a 6-week period in the spring. The estimates ranged from $22,000 to $31,000 for a complete replacement. Joel Burkett's estimate was $17,500. It arrived unsolicited. Joel had been working a job 2 streets over and had, he told my grandfather, noticed the roof condition while driving past. He had knocked on the door with a clipboard and the confident manner of someone who had done this often enough that it looked natural. Bernard had let him look at the roof from the ground and then from a ladder Joel brought from his truck. Joel's assessment was thorough in presentation and vague in specifics. He talked about the north slope, the chimney flashing, the ridge vent condition, the soffit situation. He used correct terminology. He had calloused hands and a work truck with actual equipment in the bed. He left an estimate that was $4,500 below the next lowest bid. Bernard called me before he signed anything. This is what I want you to understand about my grandfather. He is 81 years old and he has never in his life signed a document without reading it first. Not a lease, not a utility agreement, not a contractor estimate. He called me not because he needed someone to read for him, but because he wanted a second set of eyes with a legal background on a document he had already identified 3 concerns with. I drove up on a Saturday. We sat at his kitchen table, and I read the estimate and the attached contract while he made tea. The contract had the following problems. The deposit requirement was 60%. $11,250 on a $17,500 job. Michigan law does not cap residential contractor deposits by percentage, but 60% is substantially above industry standard and is a recognized risk indicator in elder financial exploitation cases. The contract had no completion timeline. The phrase work to be performed in a timely manner appeared twice without definition. The warranty language covered workmanship defects caused by improper installation, but excluded any defect attributable to materials, weather, or pre-existing conditions, which in practice meant the warranty excluded everything. The licensing information listed Joel's Michigan Residential Builder License Number. I checked the Michigan Department of Licensing and Regulatory Affairs database on my phone. The license was current. There were no formal complaints on record. I noted that the absence of formal complaints did not mean the absence of complaints, only the absence of filed ones. I amended the contract, reduced the deposit to 30%, $3,000, with the remaining $8,500 split between a progress payment at 50% completion and a final payment at completion and inspection. Added a completion timeline of 21 days from work commencement, with a liquidated damages clause of $150 per day for overrun without documented cause. Strengthened the warranty language. Added a requirement for proof of current general liability insurance and workers' compensation coverage before work began. Removed a mediation clause that directed disputes to a specific mediation service I could not verify. Joel accepted every amendment. He countersigned the revised contract without negotiation, which I noted as either a sign of genuine flexibility or of someone who had no intention of honoring any of it and therefore found the terms irrelevant. My grandfather paid the $3,000 deposit by check. Joel started work the following Monday with 3 workers. They were efficient on day 1. Stripped the old shingles from the south slope, stacked the debris in a rented dumpster, got the felt underlayment down by end of day. Day 2, they began the north slope. The chimney flashing was more involved than the estimate had accounted for, Joel told Bernard, but it would not affect the price. Day 3, they had the north slope partially stripped when Joel came to the door at 2 in the afternoon and told my grandfather there was a materials issue. The specific ridge vent system specified in the contract was backordered. He needed to source an alternative. He would have the crew back on site Thursday. He covered the exposed north slope with a tarp. The tarp was secured with 4 screws into the decking at the corners. This was not sufficient for lake effect wind, as my grandfather noted to Joel at the time. Joel said it would hold for a few days. Thursday came. No crew. Joel's phone rang through to voicemail. My grandfather called me Thursday afternoon. I called Joel's number from my own phone. Voicemail. I called the number on the contract for Premier Home Solutions. Voicemail. I looked up the strip mall office address and called the building's management company. The management company confirmed that Premier Home Solutions leased Suite 14 on a month-to-month basis, and that Joel Burkett had not been in the office in the past week. I asked whether he was current on rent. After a brief discussion about what they could and could not disclose, the property manager indicated that the most recent month's payment had not been received. I drove to Norton Shores on Friday. The tarp had held through Thursday, but a system coming off the lake that night had gotten under the unsecured eastern edge, and by Friday morning, a section of the north slope was exposed. My grandfather had been watching it from his bedroom window since 3 in the morning. He had put a bucket under the area showing previous moisture damage to the ceiling, and had done the rest of what a civil engineer does when a structure is failing, which is observe, document, and calculate. He had a notebook on the kitchen table when I arrived. In the notebook was a diagram of the exposed roof section with estimated square footage, a projection of moisture penetration rate based on the soil absorption coefficients he applied by analogy to the ceiling substrate, a list of calls made to Joel with times and results, and a calculation of daily damage accrual that he had estimated conservatively at $180 per day, based on the cost of the remediation work that increasing exposure would require. He had been running the calculation for 3 days. Day 3 of documented absence had produced damage accrual of $540. He showed me the notebook. I read it. Then I said, "Granddad, you have been preparing documentation." He said he had. I said, "What is in Joel Burkett's trailer?" He said, "Roofing materials. Shingles, decking panels, ridge vent components, flashing rolls, underlayment." He had looked at the manifest on the trailer door, which Joel had left unlocked, and which listed the contents and their approximate values. He showed me a photograph of the manifest. I looked at it. The materials on that manifest were worth approximately $15,000 to $18,000 at retail. They had been purchased, my grandfather reasoned, with the deposit money he had paid, and likely with deposits from other jobs Joel was running simultaneously. I said, "Before we discuss the trailer, I need to make some calls." I called LARA, filed a formal complaint against Joel Burkett's residential builder license, citing abandonment of contracted work, failure to respond to client communication, and potential misappropriation of deposit funds. I called the Muskegon County Sheriff's Department and spoke with a detective in the Financial Crimes Unit, named Sandra Hoyt, who had handled 3 contractor fraud cases in the previous 18 months, and who took my call with the focused interest of someone who recognized the pattern. I sent a formal demand letter by certified mail and email to Joel Burkett, Premier Home Solutions, and the strip mall office address, citing the contract provisions my grandfather had insisted on and that I had drafted, documenting the abandonment and the damage, and demanding response within 5 business days or legal action would be pursued. I drafted and sent a notice of possessory interest to the same addresses. The notice stated that the materials in the trailer on the Aquifer property had been purchased with deposit funds that constituted converted assets, and that the property owner was exercising a possessory interest in those materials pending resolution of the contract breach and damage claim, and that removal of the materials from the property without resolution would be treated as theft of secured assets. Then I sat down across from my grandfather and said, "Show me the excavator reservation." He slid it across the table. "Reserved for the following Tuesday. Compact excavator, 4-ton, from a rental company in Norton Shores." He said he had taken the operator certification course at the community college in 2019, because he had wanted to understand modern equipment controls relative to the older equipment he had operated on county projects in earlier decades. He was certified. He was insured on his homeowner's policy for equipment operation on his property. He had done the research. I looked at the reservation. I looked at my grandfather. He looked at me. "Granddad," I said, "if you do this, it needs to be documented at every stage." He said he intended to document every stage. He was an engineer. He had a survey of his property establishing the exact boundaries of his land. He had identified a location in the northeast quadrant of his backyard that had adequate soil depth, appropriate drainage, and no subsurface utilities, which he had confirmed by calling Miss Dig, Michigan's underground utility locating service. He had called Miss Dig. Before reserving the excavator, before discussing the plan with me, he had called the utility locating service to confirm there was nothing under the ground where he intended to place the trailer. He had been planning this carefully for 4 days. I said, "The legal basis is the possessory interest notice which we have now sent." The notice was sent before the action. The materials were purchased with his converted funds. The action is on his property. The documentation is complete. He nodded. He said, "I also want to understand what Joel Burkett does when he comes back for the trailer." I said that was a reasonable thing to want to understand. He said a man who abandons a job and stops answering his phone is either in trouble or planning to stay gone. If he comes back for the trailer, it is because the trailer is worth coming back for, and when he comes back for it, we will have his attention. He picked up his tea. We will have leverage to understand what actually happened. I said, "That is a sound legal theory." He said, "I know. I have been reading." The excavator arrived Tuesday morning on a flatbed from the rental company. My grandfather signed for it, confirmed the controls matched what he had learned in his certification course with 2 minutes of familiarization, and had the trailer moving by 9:15. It took him 40 minutes to dig the hole, position the trailer, lower it, and backfill. He worked methodically, the way he had worked on county road projects for 38 years. The disturbed soil was tamped level. The sod pieces he had cut and set aside were replaced. By 11, the northeast quadrant of his backyard looked exactly as it had before, minus the slight variation in grass color that would fade over 2 or 3 weeks as the sod settled. He returned the excavator at noon. He photographed the backyard from 4 angles before and after. He photographed the trailer position before excavation with GPS coordinates captured on his phone. He photographed the excavation sequence in 6 stages. He photographed the final grade. He had a folder with 47 photographs timestamped across a 3-hour window. He came inside and made lunch. I was at his kitchen table with my laptop and the case documentation I had been building. He set a plate in front of me without asking whether I was hungry, which is a thing he has done since I was 7 years old, and sat down across from me. "Now we wait," he said. We waited 4 days. Joel Burkett called my grandfather's number at 3:41 in the afternoon on a Friday. My grandfather answered on the second ring. I was sitting across from him and could hear both sides of the call because my grandfather had put it on speaker without announcing that to Joel, which was permissible under Michigan law for a party to the call. Joel said he was calling about the job. My grandfather said he was glad to hear from him and asked how he was. Joel said he had experienced some unexpected difficulties, but was ready to resume work. My grandfather said he appreciated that and asked when Joel could come by to discuss the timeline for completion. Joel said he could come Saturday morning. My grandfather said that would be fine and that he should bring his insurance documentation and a revised materials list. Joel said that was not a problem. Then he said, "While I have you, is my equipment trailer still in your driveway?" My grandfather said that the trailer was on his property. He said it had been secured as part of the possessory interest notice that had been sent to Joel's addresses, copies of which he would have for Joel's review when he arrived Saturday. Joel said he was not familiar with that notice. My grandfather said he would explain it Saturday. Joel arrived Saturday at 9:15 with the particular expression of someone who has spent a week trying to determine whether a problem can be managed and has not yet reached a conclusion. He was 43, lean, with the work-worn appearance that had read as competence to my grandfather in March, and that now read as someone who had been operating under sustained financial pressure. I was sitting at the kitchen table when he came in. He recognized me from the contract amendment process. His expression when he saw me was the specific one that people have when they realize the situation they walked into is more organized than they had expected. My grandfather poured coffee without asking. We sat. I opened the documentation folder. I said, "Mr. Burkett, I want to explain where we are and then I want you to tell us where you are." He said he was ready to resume work. I said the position was somewhat more complex than that. The contract had a 21-day completion window that had elapsed. The liquidated damages clause had been accruing at $150 per day for 18 days beyond the contractual completion date. $2,700 in liquidated damages, separate from the deposit and the damage claim. The water damage to the ceiling and insulation from the tarp failure had been assessed by a restoration specialist I had retained on day 8. Assessment was $4,200 to $6,000, depending on subsurface findings. The deposit of $3,000 was not currently traceable to materials acquired for the aquifer job specifically, since the trailer contents appeared to include materials intended for multiple projects. The possessory interest notice covered the full trailer value as security for the deposit plus damages. He listened to all of this without interrupting, which told me he had been through some version of this conversation before. When I finished, he said, "What do I owe?" I said the full accounting was $11,200, deposit $3,000, liquidated damages $2,700, minimum damage estimate $4,200. Insurance documentation gap penalty per contract, $300. He said he did not have $11,200. I said I was aware of that, which was why we were having this conversation before I filed in circuit court. I said I wanted to understand his full situation before deciding on the approach. He looked at his coffee for a long time. Then he said something that shifted the entire conversation. He said, "There are other jobs." I said I was aware there might be other jobs. He said not might be. "There are how many?" I asked. He said 11 others currently in the same position, abandoned with deposits collected, and 4 more where he had collected deposits and not started. 15 jobs. My grandfather looked at the table. I looked at Joel. I said, "What is the total deposit amount across all 15? He said he was not certain of the exact number. I said I needed him to be more certain. He said, "Approximately $90,000. I said, "Joel, do you understand what we are describing legally?" He said he understood it was not good. I said, "It is not good. Under Michigan law, contractor fraud involving multiple victims and amounts over $10,000 is a felony under MCL 750.279. With 15 victims and $90,000, you are describing a pattern that the Michigan Attorney General's Consumer Protection Division treats as organized fraud." He said his attorney had told him something similar. I said, "You have an attorney?" He said he had retained one 2 weeks ago when the first complaint was filed with LARA. I said, "Then you understand that cooperation now is materially different from cooperation after charges are filed." He said he understood that. I said, "I need names and contact information for every victim. I need the full financial accounting of what was collected and what was spent. And I need your attorney's contact information so I can coordinate what comes next with someone who can advise you properly." He gave me all 3. I spent the following week making calls. 14 homeowners in Muskegon and Ottawa counties who had been through some version of what my grandfather had been through. Ages ranged from 49 to 83. 11 of the 15 were over 60. The targeting was not random. It was the same pattern I had seen in elder financial exploitation cases for the 9 years I had been practicing. Below market estimates, high deposits, work started to establish credibility, abandonment once the deposit cleared, the calculation that older homeowners were less likely to pursue aggressive remedies and more likely to wait, hope, and eventually accept partial loss as the cost of an unfortunate experience. I called the Michigan Attorney General's Consumer Protection Division. I had a contact there from a previous case involving a home repair company that had operated a similar scheme in Kent County. The contact was a senior assistant attorney general named Philip Drummond, who had been handling contractor fraud for 14 years and who took my call on the first ring. "Adiz," he said, "what do you have?" I said 15 victims, 90,000 in deposits, one contractor, 2 counties, a pattern going back at least 24 months based on what I have been able to document so far, and a cooperative defendant whose attorney has indicated willingness to provide a full accounting in exchange for prosecutorial consideration. He said, "Send me what you have today." I sent 40 pages. Philip opened a formal investigation the same afternoon. He assigned 2 investigators from the Consumer Protection Unit, who spent the following 3 weeks interviewing all 15 victims, reviewing Joel's business and personal financial records under a voluntary production agreement coordinated with Joel's attorney, and reconstructing the complete picture of where the $90,000 had gone. The answer was not surprising to anyone who had worked these cases. $23,000 in business expenses that were legitimate. $14,000 in personal expenses that were not. $31,000 applied as operating losses to previous failed projects that Joel had completed at below-cost rates, trying to build reputation before the fraud became his operating model. $22,000 unaccounted for, in a pattern of cash withdrawals that the investigators documented but could not fully trace. Joel's attorney negotiated with Philip throughout. The negotiation was practical rather than combative because the evidence was complete. The victims were numerous. The amounts were sufficient for serious felony charges, and Joel's cooperation was the only mitigating factor available to him. Part 3, 4350. Philip Drummond filed charges in October. Joel Burkett, 3 counts of contractor fraud under MCL 750.279. Consolidated to represent the full pattern across 15 victims. The charge carried a maximum of 10 years and a fine of $50,000 or 3 times the value of the fraud, whichever was greater. 3 times 90,000 was 270,000. Joel's attorney had been negotiating toward a plea agreement throughout. Philip's office had a specific position on plea agreements in elder fraud cases that Philip had explained to me when we first worked together 9 years earlier. He said, "I do not reduce charges because cooperation is offered. Cooperation reduces sentence recommendations. The charges have to reflect what happened." Joel pleaded guilty to all 3 counts in January. Sentencing was set for March. Before sentencing, Philip filed a restitution motion covering all 15 victims with a specific calculation for each. My grandfather's restitution was $11,200, the full accounting I had presented to Joel in his kitchen in October. 11 other victims had amounts between $3,000 and $14,000. 3 victims had amounts under $3,000 because their jobs had been partially completed before abandonment. Total restitution ordered $87,400. Joel's business and personal assets were liquidated. A truck, equipment, the strip mall office furniture, 2 personal bank accounts. Total liquid recovery, $31,000. The remaining $56,400 became a restitution judgment secured against Joel's future wages, with a garnishment order that would follow him through his probation period and beyond if not satisfied. Sentencing was a Thursday morning in Muskegon County Circuit Court. My grandfather attended. He had driven himself, which he does not let me argue about. He sat in the gallery with 10 of the 15 victims and watched Joel Burkett receive a sentence of 30-month state prison, 4 years probation, full cooperation with restitution, permanent revocation of his Michigan residential builder license, and a bar from applying for any contractor license in Michigan for 20 years following release. The judge, a woman named Carol Wexford who had been on the bench for 16 years and who had handled several contractor fraud cases in that time, made a statement before sentencing that I want to describe because it addressed something I think about in this work. She said that contractor fraud targeting elderly homeowners was not a victimless property crime. She said it violated the trust that people place in professionals they invite into their homes and onto their roofs. She said it exploited the reasonable assumption that a licensed contractor was a trustworthy one. She said that the victims in this case had done what they were supposed to do. They had checked licenses. They had signed contracts. Several of them had negotiated terms. They had done everything that consumer protection guidance says to do, and they had still been victimized because a licensed contractor had made a deliberate choice to exploit the credential as a credibility tool rather than as a standard to be met. My grandfather listened to all of it with the same attention he gave everything. Afterward in the corridor, he shook Philip Drummond's hand and said, "You did good work." Philip said, "Your granddaughter built the case." My grandfather said, "I built the foundation." Philip looked at him. He said, "I heard about the trailer." My grandfather said, "I moved it to a secure location pending resolution of the contract breach." Philip said, "That is a specific description." My grandfather said his granddaughter had helped him with the language. Philip looked at me. I said, "Possessory interest in converted assets." He said, "That is a creative application of the doctrine." I said, "It produced a result." He said, "It produced a cooperative defendant 4 months earlier than we would have had one otherwise." Which is, he said carefully, not nothing. The LARA investigation ran parallel to the criminal case and concluded in December with permanent revocation of Joel Burkett's residential builder license. The revocation was published in the public database and would appear in any license verification search permanently. Philip's office issued a consumer alert for Muskegon and Ottawa counties advising homeowners about the case and recommending verification practices for contractor selection. The alert was distributed through the county clerk offices, the senior services networks, and the home improvement permit offices in both counties. My grandfather's roof was completed in November by a roofing company I had researched thoroughly. Their license had been current for 19 years with no complaints. Their insurance was confirmed directly with the carrier. Their references were called and documented. 2 of their references had been customers for over a decade. They completed the north slope, the chimney flashing, the ridge vent installation, and addressed the remaining south slope condition in 6 days. They came in at $29,400, including the water damage remediation that the restoration specialist had done in October. My grandfather applied his restitution payment against the balance. Net out of pocket beyond the original deposit, $14,200. He paid it from savings without discussion of whether it was a burden because he is 81 years old and has been managing his finances since before I was born and does not welcome unsolicited assessment of his financial position. What he did say, the evening the roofers finished when we were sitting on his back porch looking at the northeast quadrant of his yard where the sod had settled back to an indistinguishable match with the surrounding grass, was this. He said, "That young man calculated that I would not fight back." I said, "Yes." He said he did not do his research. I said he did not. My grandfather looked at the yard for a while. He said, "I spent 38 years building things that had to hold. Roads that had to carry weight, drainage systems that had to move water, structures that had to stand through Michigan winters." He looked at the spot where the trailer had been. "A man who takes money and abandons work is not a builder," he said. "He is someone who learned that the appearance of building is worth money to people who need things built." He paused. "The appearance does not hold." I said, "No, it does not." He said, "The roof will hold." "The new one?" I said, "Yes." He said, "So will the documentation." He meant the case records, the complaint files, the LARA database entry, the criminal record, the restitution judgment, the consumer alert, all of it permanent in the way that the house on the corner lot in Norton Shores, 600 feet from Lake Michigan, was permanent, built correctly by hands that understood what holding meant and built it in any way. We sat on the porch until the light went. Then he went inside and I helped him wash the dinner dishes the way I have helped him wash dishes since I was 9 years old visiting in the summers. He washed. I dried. He did not ask for help. He accepted it because it was offered by someone he trusted, which is different. When I drove home that evening, I thought about the 15 victims in this case, and the ones in the next case, and the ones after that. I thought about the calculation that certain categories of contractor fraud rely on. The calculation that older people will wait rather than fight, will absorb rather than pursue, will decide that the energy required to recover what was taken is more than they have. I thought about my grandfather at his kitchen table with a notebook full of damage accrual calculations, and a compact excavator reservation, and a copy of a possessory interest doctrine he had found in a Michigan property law reference and printed out and read carefully before he did anything. He had done his research. He had built his foundation. He had known what he owned and what had been taken from it, and what he was going to do about it with the patience and precision of someone who had spent 38 years building things that had to hold. If you have a contractor who has taken your deposit and stopped communicating, document every call attempt immediately. Photograph the work site condition daily. Check the contractor's license in your state database and look for complaint history. File with your state licensing board. Contact your state attorney general's Consumer Protection Division. Send a written demand by certified mail and email before you do anything else. And if you have materials on your property that were purchased with your deposit funds, call a lawyer before you move anything. Because the legal basis for what you do next depends on what you have documented before you do it. Hit the like button if you believe that 81 years old is not an invitation to be taken advantage of. It is an accumulation of experience that people underestimate at considerable cost to themselves. Subscribe for more stories about people who knew their rights and refused to be the victim someone calculated they would be. And send this to someone who needs to hear that fighting back is always worth researching before you decide it is not worth doing.